BlogTalk Radio.
Welcome to the AME Food Testing Show. Today's guest, Shawn K. Stevens, an equity member of the law firm of Gass Weber Mullins. He's one of the only lawyers in America who dedicates his practice entirely to representing the food industry. During the past decade, Mr. Stevens has counseled food industry clients throughout the country, including some of the nation's largest food producers, national restaurant chains, and several food distributors and grocers, on a wide range of food safety, regulatory, and liability issues. Mr. Stevens works closely with food companies to identify and manage risk, plan, and prepare for possible crises, and also respond appropriately to government enforcement actions and recalls. Mr. Stevens has also defended the food industry clients against high-profile foodborne illness outbreak claims in more than 20 states throughout the country. Today's topic, legal response to an FDA inspection, Form 483. Shawn, do you have anything to add to that introduction?
No, thanks, Andy. I thank you very much for a wonderful summary of what it is we do and our background.
Great. Today's topic, legal response to an FDA inspection, Form 83, begins with the general inquiry. What is a U.S. FDA inspection?
Well, Andy, an FDA inspection is a mechanism by which the federal government will come in and assess how well a food company is doing its job in processing safe and wholesome food. And I think it's important to properly put an FDA inspection into context, talk a little bit broader about why we care about inspecting food in the first instance. There's a few things in this country nationally that we value. In addition to our security and our defense, is of course the food that we eat. It has significant implications not only for the health and welfare of the country, but also, in many respects, our continued existence and prosperity. So we as a nation, and by extension our federal government, have taken the issue of regulating our food supply quite seriously. Back in 1906, after Upton Sinclair published The Jungle, highlighting the various insanitary conditions that existed at that point in time in slaughter facilities throughout the country, the federal government responded by creating the Wholesome Meat Act. What that did is it created, in essence, the USDA and what is now known as the Federal Food Safety Inspection Service, and mandated that federal inspectors maintain a continuous 100% on-site physical presence inside meat slaughter facilities. Over time, additional rules and laws were applied to other foods, and those are regulated by the FDA. And I just want to, for a moment, just talk about this distinction, then we can roll into more detail what it is that the FDA is tasked to do and how it does it. So USDA will find USDA inspectors physically present in all beef and meat slaughter facilities throughout the country. That includes beef, pork, poultry, and they're also responsible to a certain extent in regulating eggs. And federal inspectors are in those facilities every single day, making sure that those companies are processing food in a way that when it's shipped out into commerce, it's safe and wholesome. On the FDA side, and part of that too is because we're dealing with, on meat side, live animals that can carry disease and issues with respect to raw animal foods. And early on, those types of foods, because they're quite perishable, it was thought that we needed more attention focused on meats. Meanwhile, while FDA regulated all other foods other than meat, poultry, and beef and pork, they didn't have a physical presence inside those facilities, and mainly that was because there was less risk perceived to be associated with other types of food. For instance, we're not as concerned about animal disease in a canning factory. So over time, FDA adopted basically an inspection scheme whereby it would periodically inspect these other facilities as opposed to maintaining a physical presence in them and assess how well they were or were not doing. And depending on the state, it sort of remains true today, although there's a lot more intensity and some guidelines that will be issued to the FDA as to how frequently they have to inspect facilities. But over time, we would see some food facilities in some states being inspected once or even twice a year, either by the FDA itself or by state inspectors who were authorized by the FDA to perform those inspections on their behalf. A few years may go by before a facility is actually inspected. So the way that the current rules are applied to the food industry as it relates to FDA inspections of food processing facilities are not uniformly enforced nor applied. And we see great disparity across the nation with respect to how often the FDA inspectors are really getting into those facilities and sort of pulling back the curtains and assessing how good a job they are doing.
So when would normally such an inspection occur, given that infrequency and that variance of time period?
Right. So in the past, it was a little ill-defined. Now, with the enactment of the Food Safety Modernization Act, there's some additional guidance. I'll talk a minute about that, and then I'll talk practically about what really happens. The guidance issued by under FSMA basically states that to the extent a facility is producing a high-risk food, and there's a number of criteria that the agency uses to determine whether the food someone is producing is high risk, including whether it's generally known to be associated with or have a risk of carrying foodborne pathogens, has been associated in the past with foodborne illness outbreaks, a few other standards, etc. If it's a high-risk facility, those facilities, the FDA has been mandated to inspect at least once every 3 years. And it could be more frequently than that. As noted, there's some states in which some of these inspections are occurring once or twice a year. For non-high-risk foods, and those would be foods that typically have not been associated with substantial issues, those facilities the FDA is required to inspect once every 5 years on a going forward basis. But there too, the frequency may even be more depending on where the facility is located. Now that's what the guidelines and the standards say. But in reality, what we see is there's and those are routine inspections that just need to happen because the FDA is tasked to do it. There's other types of inspection that sort of fall within, or I guess maybe between the lines, or under the umbrella of FDA inspections. And other than the routine inspections, again, every 3 years for high-risk foods or every 5 years for non-high-risk foods, we also see inspections that are triggered by reports to the FDA's reportable food registry. We see inspections that are triggered as a result of a complaint issued by a consumer to the agency. We see inspections being triggered as a result of a foodborne illness investigation, often tied to an emerging outbreak. And what happens during these inspections can vary significantly depending on whether they're routine as a result of a reportable food registry report or a complaint. And the intensity by which the inspections will occur varies as well. And we can get into some of the details on that if you'd like.
Yes. Well, let's talk about that for a minute. You have had clients, I've had clients that have had these types of inspections. Let's chat for a minute about what flowers after one of these inspections. Is it the Form 483?
Right. So Form 483 is basically the agency's way of memorializing what it is they saw. Now, I think it's important when we talk about the 483 because there's going to be a wide spectrum of information that's going to be recorded in there. And what's recorded ultimately depends on the, I would say, intensity of the inspection taking place. So one of the things I like to do with my clients when we talk about what is an FDA inspection and what to expect is to sort of quantify what it is that they want. And once we understand what it is that they want, to the extent that there's issues, we're in a better position to respond to any concerns they have if a 483 is ultimately issued. So from a broad, and let's kind of start with maybe the broad funnel again and then narrow it down, and ultimately we'll land on the 483. There's a couple things that's important to understand when FDA inspectors come into a facility. The first thing that they want to do is, or they want to achieve or ensure, is to protect the public. So it's important for clients to understand that going in, that's going to be the mindset of the inspectors walking through the front door. The second thing those inspectors want to do is, and I don't want to oversimplify things, but they want to keep their jobs. We all have certain duties and responsibilities in our daily jobs, and we have to report to our superiors. So we, as clients, when FDA inspectors come into our facility, we have to understand and recognize that there's certain things that they are tasked to do and their superiors will expect them to do, and they want to keep their jobs. So they're not going to cut corners, or they're not going to tolerate obstruction or inadequate responses from the company, because they have to answer to somebody as well. So I think from a psychological standpoint as well, when we're dealing with these inspectors, it's important to keep that in mind. Now, what's going to happen? Well, during a routine inspection, and again, with an eye towards ultimately what will likely result in a 483 following an inspection. With a routine inspection, generally a facilities inspection, observations regarding what the inspectors can just see. There's going to be an element of records review, and moving forward, once the written food safety plan requirements are finalized, inspectors will want to review and look at a company's HACCP programs or written food safety programs, a topic perhaps maybe you and I could chat about at some other date. It would be an interview in of itself. They may take photographs of the facility, which raises some interesting questions about what a company should do in response to a request by the agency to take photographs. And I have some thoughts on that. Again, it could be a separate topic, but generally speaking, although the authority isn't completely white and black, it's a pretty dark shade of gray, and FDA will likely be able to establish with a court, if they have to, that they're entitled to take photographs of your facility. Certain things companies can do to mitigate whether the agency will or will not feel it's inclined to do so during inspection. Something, again, we can talk about in more detail at a later date. They also might want to take microbiological testing of product contact surfaces, floor drains, walls, ceilings, fans, and the product itself. There, too, there's a host of issues that relate to whether we take companion samples, sister samples, and if we do, what we do with them, and ultimately what's going to happen if a positive is found. The not-so-routine inspection, I'm often asked, so, I mean, with the routine inspection, bottom line is the FDA has a lot of access to what's going on in the facility. There are pretty stringent limits, but they'll be able to look at records relating to the food safety programs of the company. They'll be able to take observations. They'll be able to, when push comes to shove, likely be able to take photographs, and of course, microbiological sampling and waiting for the results. To the extent it's a not-so-routine inspection, and this would be an inspection that was triggered by a foodborne illness complaint or an emerging foodborne illness investigation. In those cases, the FDA will have access to far more information. And here's where I think the authority granted to the agency by the FSMA is actually jaw-dropping. The standard FDA has as it relates to access to a company's records during a not-so-routine inspection is as follows. If the FDA believes, note the word believes, that there's a reasonable probability that the use of or exposure to your company's product will cause serious adverse health consequences or death, then the FDA shall have access to the records that are needed to assist the FDA in determining whether there is a reasonable probability that the use or exposure to your product will cause adverse health consequences or death. So the standard really is if the agency suspects, if it believes, if it has a hunch that your product might be getting somebody sick, let's say they see some rat droppings in the corner on the floor, and they use that to frame the opinion that they believe that some products may have been contaminated, then they will have access to any records they need, and that's the legal standard that's been granted to the agency, any records they need to figure that out. So it's a massive, very broad grant of authority and power to the FDA as it relates to what they will have access to in the event of a not so routine inspection.
Hey, Shawn, can I interrupt here for just a second?
Yeah, absolutely.
Where are our constitutional rights against the government just taking things from a private property?
Right. So the Constitution, of course, would play a role here. The agency's response in the face of an emerging foodborne illness outbreak, an emerging public health event or crisis, the agency would articulate to whatever court would be asked to answer the question to the extent constitutional objections are raised, and would say, people are dying all across the country. We do not have or two people potentially could be dying, and we do not have the ability to solve this problem unless we have access to these types of information. Would the agency bring those arguments and try to skirt the Constitution in a case where they own the best evidence they have is rat droppings in a corner? Probably not. But they could pick a test case involving a large-scale outbreak with a lot of confirmed cases, questions about the source, and a company attempting to withhold information that it feels it's legally entitled to withhold. And in a case like that, court might be willing to sort of set aside, you think about sort of martial law standards, some of those principles for just a moment so that the agency can solve the public health issues. So I think that's where those two important principles ultimately collide. And what results from that at this is hard to predict. The authority is new, and I haven't seen any challenges to it yet, but I would anticipate within the next decade there will be an instance or two where we will.
Excellent. Well, let's keep going here. Let's review
Great.
The entire powers and what the 483 represents for the food producer.
Right. So what's going to happen is after the inspectors have completed their investigation, what will occur is they will make a determination based on all the evidence that they have collected whether there are any perceived food safety issues or health risks associated with the processing of the foods in question. And to the extent that they determine that, or if there's any inconsistencies or violations of the regulations as it relates to the types of records that are to be maintained, what the records say, what the company is doing vis-a-vis what the records suggest it should be doing, how it's executing its programs, et cetera, et cetera. To the extent that there's any perceived violations or inconsistencies, those types of observations would be recorded by the agency in the Form 483. Now, again, this form is merely a mechanism by the agency to write down its observations and create a written record. Now, the company typically, during the course of an inspection, will accompany the FDA inspectors, or at least they should. And there may be certain observations that are made during the course of the inspection or questions that are asked that the company could or should immediately respond to. So it's a question about mouse droppings in a corner. Of course, the company would immediately have their QA folks go and fix that or remedy that problem. So a lot of the corrective actions that are going to stem from observations or concerns of the agency will be triggered immediately during the course of the inspection, or they should. They still nevertheless may get recorded in the 43. The company's position may be, well, hey, we've already fixed it, but the agency may have deeper concerns. Okay, fine, there were mouse droppings in the corner, and while we were going through the inspection, you cleaned them, but what the agency might really be concerned about is why were they there in the first place? And what assurance do we have that they're not going to be there again? So while a company is not obligated to respond to a Form 483 once it's issued, and there's no legal requirement mandating that a company issue a formal response to a 483, I tell my clients it's critically important that they do. the sort of unwritten rule of thumb for a response to a 43 is 15 days. So if an inspection occurs, a 43 is issued, the company could just do nothing. They could file it away and continue to operate. And we'll talk about what might happen if they choose that course. The other path, alternative, the one that's highly recommended, is to take those observations incredibly seriously, create the impression with the agency that you're taking those observations incredibly seriously, and do what you can to address those concerns head on and very formally and professionally with a written response. And the written response then will articulate, with respect to each observation, what corrective actions had already occurred during the course of the inspection or after the inspection, as well as the root cause of some of the concerns that the agency had, and then what the company is doing or implementing to ensure that those issues are fully solved and will never happen again in the future. Why is that so important? Well, because of what's called a warning letter. If the agency's concerns are substantive enough in the 43, and that company does not respond to the 43, now again, the folks who are doing all the paperwork at FDA and writing these reports, they have to answer to their superiors. And if there's something in that 43 that could cause significant food safety concerns and the company doesn't respond, then the agency only has one option, and that's to issue a warning letter to the company basically saying, we issued this 43, and there's some pretty significant concerns in there. It's been radio silence, and as a result, we may need to shut your company down. So the FDA will issue a warning letter, which will mirror all of the observations in the 43, and then say, if you don't respond within a certain amount of time, we're going to shut you down. Now, the other problem with the warning letter is it sort of elevates the seriousness of what's happening. It's also going to be published by the FDA on their website. So everybody in the world, including your customers, will be able to see it. So if we can cut that off at the pass, when we get a 43, even if we don't think it's that serious, somebody else might think it is. So even if we don't think it's that serious, it's critically important that you sit down and put together a response. What I do with my clients is, we represent a lot of different companies and a lot of different segments of the industry. My clients are experts in their operations. My clients are experts in processing the foods that they sell. My clients are experts in their programs. I let them draft the response. I'll give them sort of the general parameters and the tone, what the agency is going to want to see, what I think they should address, what I think is most important in what order. I'll let them do the writing. And after that, we'll just sort of tweak it and massage it and make sure it's in a tone that whoever's reading it at the FDA district office at the end has a smile on their face and says, okay, this company's good to go. I can focus my attention elsewhere.
Well, Shawn, that approach seems to be very reasonable. What if we have an unreasonable 483 and then an unreasonable follow-up with a warning letter and the threat of closure of the facility?
Yeah, typically what'll end up happening is it's really a ballet, this process, a dance, so to speak. And each one of these is always going to kind of end the same way, unless there's incredibly extreme circumstances, and I haven't yet seen those. But the dance goes something like this: 43 is issued, company responds, and it may have been triggered as a result of observations, or it may have been triggered as a result of positive listeria findings on the floor next to the processing line, or by listeria findings on a product, which triggered a recall. But a 43 will be issued. There might be 10 or 15 or 20 observations, some of which are not that important, some of which are critically important in the minds of the agency, some of which we may completely disagree with how significant they are, or we think that the agency is just going out of their way to create tension and issues that may not truly exist. But from our perspective, and from my client's perspective, what I tell them is that those are the instances, at least at the outset, where we have to swallow hard and do our best to respond in a way that that person who's going to be reading it and then reporting to their superiors when that meeting takes place says, yeah, I turned the screw, clamped down on the wrenches, and we got this company to comply, and we're good to go. As opposed to, we've issued all these observations and requests, and the company is dragging their feet, or they're fighting with us. We need to increase the intensity, and that's the road we don't want to go. With that said, with the observations, really important that the company do a couple of things. Number one, acknowledges the programs that they do have and how robust they are and how great they are and how incredibly successful that they have been in producing, ensuring they're producing and distributing a safe product. Then with respect to this one exception, talk about how great it is for the opportunity, or thank the agency for the opportunity to work with it in order to enhance or refine or better those food safety programs. And a lot of consequences that roll from these. There may be litigation at some point where people are bringing claims, and you want the tone to be such that you're not necessarily conceding that something was your fault, but you're also addressing the agency's concerns. And then with respect to each observation, the critical elements are acknowledge the observation without necessarily accepting the veracity of it, but acknowledge the observation, acknowledge the importance of that observation in solving or addressing the agency's concerns to the company, acknowledge that it has been remedied or corrected, acknowledge or talk about what the root cause was, even if you, again, disagree with the significance of that observation. It's important to go through this process. And then memorialize or articulate what the company is doing to ensure it won't happen again. Once those elements are satisfied, we move on to the next slide. That's what the agency needs for its files, and that's what we have to give them. The next step of the dance after that, and then always back up your statements with exhibits attached to your response. So to the extent you're saying, we have performed additional employee training to ensure that this doesn't happen again, make sure you attach the documented training logs so the agency can see that what you're saying is supported. If you say we revised our policies and procedures as it relates to sanitation in this respect, and as a result, we know that this will never occur again, then attach that revised policy and procedure to your response so the agency sees that your response is adequately supported. Once that's turned in, the next step of the dance is the agency will come back, and instead of having 20 concerns that are articulated in the letter, it'll have some follow-up questions with respect to your responses. And maybe we started with 20, now we're down to 8. And it always happens. So you'll get a follow-up letter from the agency saying, well, okay, thank you for your response. We're not going to shut you down yet, but we still have some remaining concerns. Those will be articulated, and then it will be the company's opportunity to respond to those directly. Once that process is done and the letter is turned in, the agency may come back now with 3 follow-up questions. And you see we're just kind of bracketing things until at the end of this ballet, the end of this dance, ultimately the agency will have padded its file sufficiently so that if there's ever a problem in the future, they can say that they were on top of this company, that they issued their 483, that they ensured before they lifted their warning the company was producing safe and wholesome product. At that point in time, they'll finally issue their closeout letter, and then it will be business as usual.
Shawn, let me ask you, if even at the end of that dance, is there a possibility that the company A will pay a fine, B will be re-inspected, or C actually close down even if they've complied with all of those things?
Yeah, we'll start with the last one. Actually, the company shutting down, I cannot envision any circumstance where if the company is adequately responding to the agency's concerns, that they're going to shut the company down. I think it is a tremendously rare event. It's not something that the FDA is really interested in doing. I think to the extent a company is doing its best, the agency will lose credibility. There could be a scenario though where a company, without the benefit of skilled consultants like yourself or food safety regulatory lawyers like myself prepares a series of responses that are deemed to be inadequate by the agency and don't really get to the root cause, and the company and the agency are talking past one another, that's the type of scenario I think ultimately you end up where the agency will shutter the doors. With what we just went through, that dance, that ballet, so long as that occurs as I described, I think it's the chances that the company is ultimately going to get shut down by the agency are almost non-existent. With respect to follow-up inspections and fees, yes, after a warning letter is issued and the company makes its response, or even after a 483 and a company responds, I would anticipate, at least within the next few weeks, if not the next couple of months, the agency will return, even if only to make sure that what you stated in your response is actually being done. So it's very important when we're preparing those responses to make sure that we're not making any promises that we can't keep. And that once it's done, we're actually doing what it is we said that we're going to do. As far as a fine, the agency won't fine a company per se. But what can happen is under the Food Safety Modernization Act, to the extent the agency deems it necessary to come back and reinspect the company, the agency can charge that company fees for the inspector's time. And currently the fees that the FDA would be entitled to approximate, it's about $350 an hour. So it could, potentially become rather pricey if the FDA feels it has to spend a significant amount of time with one or maybe more inspectors in your facility following the issuance of a 43.
So I guess the ultimate question is, how do we avoid such situations for our clients?
Right. I guess a couple things are happening right now. My advice to clients is do your best to forge strong relationships with the inspectors who are currently in your district. We need to recognize that with the Food Safety Modernization Act now in effect, the written food safety program requirements that are soon going to be applied, and the agency's lack of additional funding to enable it to conduct all these extra inspections, here's how this scenario is going to play out. The agency is going to be questioned, and it will publicly, about whether it's really doing its job, it's performing adequately its responsibilities under the new Food Safety Modernization Act. And the agency's response to that is going to be, of course we are, okay, even though they don't have any additional funding. And then the other question will be, well, is the act actually effective? Are we actually vetting out bad companies? So practically, here's how it plays out. In every district around the country, as the FDA is trying to figure out, well, who are we, as it relates to written food safety programs, and we have to go in and we have to make sure that these programs are effective as part of our routine inspections. What are the companies? They're sitting in the boardroom and they've got the marker board, and they're saying to themselves, okay, well, what are the companies historically we've had problems with, or there's been tension, or didn't want to let us in, or didn't want to allow us to take photographs, or which are the companies that we have a really poor relationship with, right? And personally, and we see that sometimes. Sometimes some companies and the inspectors that are there, it's like oil and water. But they're going to be sitting around a table, and it's not going to be necessarily based upon, it's not going to be on alphabetical order. I'll tell you that. It's going to be, let's write down the names of those companies that we've got a vendetta for. We're out to get. That may be a little extreme, Andy, but we're all human, right? And they're going to get that list of companies, and those are the companies that the agency is going to go in and focus most intensely on. So today, before we get to that point, let's recognize that these inspectors, the folks at the district office, when they make those determinations, recency is going to be on their mind, their most recent experience with these companies. So to the extent we have inspectors coming in now, or to the extent we're dealing with issues with inspectors, really important to do what we can to strengthen the relationships that we have, to make it appear as if we're kind of going out of our way to help them do their jobs. Because if we create that impression, then when they're in that boardroom, they're thinking, well, we don't have to deal with that company. I was just out there a couple weeks ago, and those guys were awesome, so we don't have to worry about them. Let's focus on somebody else. The other thing I think it's critically important is during the course of an inspection, we gotta recognize that these inspectors, again, they're coming in the facility. They're human, okay? And we want to make them feel like we care. You know, they come into our facility, they're going to expect certain things, respect, and they're going to want to feel before they leave like we care that they're there and we're taking it really seriously. So we have to act like it. We want to teach them about our product and our process. And one of the ways to do that is have the CEO of the company accompany the inspectors. Instead of just appointing a lowly QA person, why don't we put the CEO or the plant manager in that group? And that inspector will then feel, oh, wow, yeah, they're treating me, you know, my business here really important. They're taking it seriously. It'll make them feel good, and they'll probably be less likely to go out of their way to find issues. This also creates a nice opportunity to teach the inspectors about your process and your product, about all the great things that you do that you're proud of, all the wonderful enhancements that you've made and the investments that you've made in money and all that jazz. Because if you're not talking about that, if you're not selling your facility, right, nobody else is. So we want to kind of help guide them and show some of our pride, show some of our excitement and our passion in what we have in place. We don't want to be defensive if they have critical observations. We don't want to get our backs up because that just creates tension, right? We say, oh, you know, thank you so much. You're absolutely right. We're right on it. We're gonna hammer it. We're gonna solve it. Okay, and you don't have to feel like you're perfect. FDA needs to find something in these inspections. We've got to recognize that they have to find something, otherwise they're going to be perceived as not doing their jobs. So if they do, let's not get defensive. Let's just smile, thank them, and tell them it's going to be solved immediately. We want to lead the FDA, I guess, to the cause of a problem and also a solution. So if you go back to our rat droppings, again, we're not going to get defensive. We're just going to say, okay, you know what? Here's what we have done in the past to solve this. And apparently that's not effective. So not only cleaning it, we're going to do X, Y, and Z. And I promise you it's not going to happen again. Always show respect and concern with inspectors. Unfortunately, we're all human again. Some of them will feel like they're entitled to it. That's unfortunate, but we need to show them respect. Just like that officer who pulled you over when you didn't think you were speeding, he thinks you were speeding. And if we don't show respect, it's not gonna help our case.
Well, Shawn, that's an excellent suggestion. And I will contribute my personal experience is that when they come out, it's not just the FDA. You'll generally have a public health officer which comes out in camo gear. I'm talking about jungle camo military gear with military boots. And then you'll have state health department or health inspectors as well. There'll be a team. And there'll be multiple people, multiple personalities. Has that been your experience?
Yes, absolutely. Again, depends on the type of the inspection, the reason why it's occurring. But it gets us back to this point. You know, these folks have been hired, go to work every day and come home at night, thinking that they're incredibly important and critical to preserving or protecting the public health. And as a result, when they show up in their SWAT gear and they're kind of fanning out across the facility, we just got to be cognizant of that. And we want to create the impression that we're the friendly village and we're here to help, and we're going to root out any bad guys that might exist, you know, hiding in dark corners, as opposed to starting to put up and build walls and then hiding behind them, if that makes sense.
Perfect sense. Well, Shawn, you have given us an excellent summary of the situation. What kind of services would you suggest in the event of one of these inspections and then the 483?
Sure. So typical scenario plays out like this. Client gets notice that inspection is going to take place or is about to take place. I'll get a telephone call. We'll find out the reason why the inspectors are there, and we'll quickly go through, very similar to what I did, but in an abbreviated fashion, what to expect. We'll talk about a couple likely scenarios as far as micro-testing or photographs that might be taken, and I'll go ahead and arm my client with responses and a couple scenarios that might play out and what to do in the event of any scenario, and then let them go and complete the inspection. Following the inspection, we'll just sort of get back on the phone. We'll assess what happened. Most cases, I can put my client at ease, and we'll wait and see if the inspection generates a 483. If it does, critically important to get involved immediately. Pull the team together, usually a brief phone call to talk about what the observations are. We circulate the document. We sort of outline a general response. I'll talk a little bit about what the agency, there might be 5 or 8 or 10 pages of the 483, but, only 2 paragraphs really matter. And we'll talk about that and what we're going to do about it. And client will go out, draft, with their team and their expertise, draft the response. We'll take a look at it, make some refinements, massage some things, provide some additional input, maybe send the client back to do just a little bit more. Once that's done and finalized, client sends it out. And in most cases, that ends it. Nothing else happens. If a warning letter is issued, same process. But we just spent a little bit more time making sure that everything and every concern of the agency is being appropriately addressed. The message we want to send is, we're here to ensure that any concerns you have are immediately and completely corrected. And at least in every case I've worked on, we've been able to do that.
Excellent. Well, Shawn, would you like to summarize then our conversation today about the U.S. FDA inspection, the 483, and any final suggestions you might have for food production, food quality, food safety, and food security managers?
Absolutely. So if we produce food, we know that at some point in time, the FDA is going to be knocking on our door. It's critically important that when that happens, we know what to expect. And what to expect really comes down to a couple of things. Again, inspectors are there to protect the public health, and they're there to make their superiors happy. So in our attitude, in our interaction with those inspectors, we just want to do whatever we can to make sure that they feel when they leave like they're protecting the public health. There's no issues that have remained unresolved, and that they have had all of their questions appropriately answered, so that when they go back and report to their superiors, they're not going to be questioned about the job that they did. If the FDA has any concerns, we're of course going to address them immediately. We're going to create the impression that we care very deeply, no matter how insignificant the concern, and that we're going to address it instantaneously because we take their concerns extremely seriously. And if we find ourselves in a difficult position with a 483 or warning letter, we have to tell ourselves, first off, this problem can be solved, and it can be resolved, and we can put ourselves in a position where our operations are better, our company is better, and the next time the FDA shows up, we're not going to go down this road pretty simply, but we just have to approach it the right way, and that's having the right tone and recognizing, again, they're here to protect the public health, so it's our job to help them.
Excellent summary, Shawn. I'd like to express my appreciation for your time and your investment, realizing that a lawyer's time is his stock in trade. And I'd like to allow you to tell us about your broad range of services that you and your firm provide to the food industry.
Well, thanks, Andy. So for more than a decade now, we've been working exclusively with the food industry, doing a lot of different things, helping companies reduce and manage risk, working with companies to audit their operations and their programs and procedures and their facilities to identify areas where they may have some exposure, either in the context of an FDA inspection or litigation as it might relate to foodborne pathogens, potential contaminants, and ultimate lawsuits or recalls. So we can work very closely with companies, and we do, to identify sort of what the risk exposure is and to narrow that window, that exposure window, significantly and very efficiently. We also work very closely with companies in regulatory compliance. We all have questions about what is the agency going to require in the coming months? What do they expect? What are the current requirements? Or perhaps the agency has certain questions or is expecting certain things of a company, of course, working closely with those food manufacturers to make sure that they know where they stand from a regulatory standpoint, that to the extent that there's anything they need to be doing, it's being done appropriately. Then, of course, in the event that there's outbreaks or recalls, we defend companies in foodborne illness litigation throughout the country, working with them to protect their interests, protect their brand in the context of high-profile and high-stakes foodborne illness litigation throughout the nation. So it's really the full set of food safety services. If it relates to food and the law, we've got our fingers in it, Andy.
Outstanding. Again, thank you for your time and effort, and I appreciate your invitation for these other topics. I think they're timely and necessary, recognizing that food safety is increasing both in importance and in press and in liability.
Right.
Thank you again, Shawn, and I'd allow you to, again, close with any final closing comments you might have, and then wish you a great day.
Sounds great. Well, thanks so much, Andy. I appreciate the invite, and I, of course, as always, look forward to chatting with you more.
Great. Well, have a great day, Shawn. Thank you very much.
Thanks. Bye-bye.
You bet.